Today's question has to do with a trust owning property in multiple states, or how can a trust own property in multiple states. I recently got a call from a potential client who lives here in Wisconsin in the summer, but lives in Florida for 6 months in the winter. She met with a Florida attorney who told her she could form a Florida trust and transfer both her Florida residence and her Wisconsin residence into the trust. That's correct and is one of the great things about the trust. I explained to her that this would help her avoid probate in 2 states. Instead of dying with a will and leaving a probate estate in Florida for her house there, and another probate estate in Wisconsin for her home here, she can form this Florida trust and deed both properties into the name of the trustee holding the property on behalf of the trust. That way she avoids both a probate in Florida and in Wisconsin, easing the administration of her estate following her death. Her question for me was how she would do this. I advised her to wait until she has that Florida trust formed, then give me a call and I'll help her transfer her Wisconsin property via deed into the name of the trust. It can be done the same in reverse if you had a Wisconsin trust and wanted to put a Florida property in. That's the great thing about revocable living trusts. They're a flexible way to avoid probate in many states. Great question and thanks for asking.